Yes. Appear for the state. Before I begin my arguments, I would request the court to kindly permit me to give three very important dates. Karnataka has the then princely state of Mysore.
Yeah.
Was the first country to implement the policy of reservation. It happened in the year 1874.
Yeah.
Soon after the first census was taken in 1872. So from 1874, we have the reservation. And the first quasi-judicial body to investigate into the claims of backward classes was constituted in the year 1918. It was presided over by an illustrious Chief Justice of this court, Sir Leslie Miller, whose report was accepted and implemented from 1921, as a result of which, on a rational basis, we had the benefit of reservation, and that continued till the Constitution came into force, and it was continued thereafter, even after the princely state of Mysore joined the Indian Dominion in 1948. Then the states were reorganized in 1956. Totally 5 different regions, namely Bombay Karnataka area, Hyderabad Karnataka area, Kodagu, and parts of Madras Presidency and the princely state of Mysore were brought together to form the new state of Mysore. That happened on 1/11/1956. With this development, the lists that were in operation in the other regions came to be consolidated and introduced, but then it was noticed there was a lot of incongruity in the operation of the list because of the repetition of the names, etc. A committee was formed, namely Dr. Nagangowda Committee, to go into this question in the year 1960, after the new state of Mysore was established. Nagangowda Committee gave its recommendation, which was modified and accepted by the government, providing for reservation in favor of the backward classes and the scheduled castes and scheduled tribes. This was the subject matter in M.R. Balaji versus State of Mysore, which for the first time laid down the rule of 50%.
Yes.
So with these few facts, the later developments are very well known. How the Nagangowda report was struck down in Balaji. So there was no reservation for backward classes from 1962 till 1977. But the scheduled castes and scheduled tribes enjoyed the benefit of reservation throughout.
Yes.
I'll take the court through the details later. My first proposition in defense of the present legislation is that the 50% rule invented by Balaji is no longer in operation. It has been obliterated by the constitutional amendment 103rd amendment by which new provisions were introduced providing reservation in favor of economically weaker sections by inserting clause 6 of Article 15 and clause 6 of Article 16, both for purposes of education under 15 and for services under the state under Article 16.
Yes.
Now, why I say that the 50% rule is no longer in operation, notwithstanding the earlier judgments which have repeatedly laid down 50% as the ceiling on reservation. Now that is because Balaji was based on a statement made by the father of the Constitution, Baba Sahib Ambedkar, on the floor of the Constituent Assembly. Which indicated that the quantum of reservation should be minority of the seats. Now, this was the indication which was gathered by the speech made by Baba Sahib Ambedkar. Now, that speech is already placed before the court by my learned friend, Mr. Prithvish. So, I'll not, may I request the court to kindly permit me to revisit that speech for a while.
Yes.
Constituent Assembly debates ಕೊಟ್ಟಿದ್ದಾರೆ. Article 296. This is dated 30/11/1948. Speech made on 30/11/1948. I think my learned friend had placed before the court a
Yes.
printout of the speech.
You will not place a printout. Refer to the books.
This is
Article 16.
is it
This is a debate.
the Constituent Assembly debates? Sir? Oh, no, this is commentary. The debate as on 30/11/1948 when Baba Sahib Ambedkar introduced the draft constitution.
Yes.
Please. Now the discussion starts with Sri Loknath Mishra, then K.T. Shah, Alladi Krishnaswamy Iyer, Hridaynath Kunjru. I will not trouble the court with those speeches because what is considered is a speech made by Baba Sahib Ambedkar in reply to all these interventions.
Yes.
And his speech starts like this. May I quote? My friend, Mr. T.T. Krishnamachari. That is how it begins.
Yes.
Yeah. Kindly skip that that paragraph, next paragraph also. And thereafterwards, next page, last paragraph. Now, sir, to come to the other question, which has been agitating the members of this house, namely the use of the word backward in clause 3 of Article 10, I should like to begin by making some general observations. So this is how it begins. I'll not trouble the court with the major part of it. Kindly come to the next page, where in the copy given to me by my learned friend, it is in italics.
Yes.
Yes, that may kindly be read. It cannot be, in my judgment, therefore, the seats to be reserved. If the reservation is to be consistent with subclause 1 of Article 10, must be confined to a minority of seats. Kindly mark it. So it was emphatic statement that it should be confined to minority of seats. It is then only that the first principle could find its place in the Constitution and effective in operation. If honorable members understand this position, that we have to safeguard two things, namely the principle of equality of opportunity, and at the same time satisfy the demand of communities which have not had so far representation in the state, then I am sure they will agree that unless you use some such qualifying phrase as backward, the exception made in favor of reservation, kindly mark it, sir. This is important. Exception made in favor of reservation will ultimately eat up the rule altogether. I'll stop at that. Now, in the first place, what was considered as an exception, even Balaji reiterated that principle, has now been made as a special provision under Article 16(1) itself. Now, this was the draft Article 10(3), and it referred to minority of seats, and it referred to the reservation being an exception to the general rule of equality. Now, having said this, I request the court to kindly proceed to the next paragraph. I'll trouble the court with only one sentence there. Opening sentence in next paragraph. With regard to the minorities, kindly mark it, sir. With regard to the minorities, there is a special reference to that in Article 296, where it has been laid down that some provision will be made with regard to the minorities. Unfortunately, this has not been placed before the court either in Balaji or in Indrasani or any subject. This very important, this thing, even before this honorable court, nobody read this. Yes. This is a very critical statement made by Baba Sahib Ambedkar, namely, minorities will be separately taken care of. Why did he say so? That is because draft Article 296 had a, I don't know if draft constitution is there. Shura. Yeah. Shura volume 3. Page 631, if it is not altered, this is a subsequent edition. 631. Article 296. Yes.
Yes.
Sir, Article 10(3) became Article 16(4).
Yes.
296, as it originally stood when Ambedkar made this speech, it is very important to take note of it. Somehow it has missed the attention of all the courts so far. 296. This is the provision to which he refers. Subject to the provisions of the next succeeding article, the claims of minority communities shall be taken into consideration consistently with the maintenance of efficiency of administration, in the making of appointments to services and posts, in connection with the affairs of the union, or of a state for the time being specified in part 1 of the first schedule. So it provided for reservation in favor of minorities separately. Who are the minorities so referred to? The Sikhs had a separate reservation. The Muslims had separate reservations. Now this was taken care of under Article 296. Now thereafterwards, kindly recollect, because of the persuasion of Sir Vallabhbhai Patel, the then Deputy Prime Minister of India, he was able to prevail over the minorities to give up their claim for reservation. So 296, which was a provision for the minorities,
Yes.
underwent a metamorphic change, and it now reads as Article 335. Kindly permit me to show Article 335. Constitution, Barak.
Yes.
Earlier provisions said special provisions regarding the representation of Anglo-Indian community in the legislative assemblies of the states, claims of minority communities too, etc., etc., services and posts.
35 is for
296, that is how it said earlier. The title to Article 296. That can be seen at the margin. Now instead of the claims of minority communities to services and posts, now the title of Article 335 heading is Claims of Scheduled Castes and Scheduled Tribes to Services and Posts. The claims of members of scheduled castes and scheduled tribes shall be taken into consideration consistently with the maintenance of efficiency of administration in the making of appointments to services and posts in connection with the affairs of the union or of a state. I'll not trouble the court with the proviso. So what was a provision for minorities has now become a provision for the scheduled castes and scheduled tribes.
yes.
Sir, this is one provision, Article 296, which has missed the attention of the courts, right from Balaji,
Yes.
which has resulted in a slapping of a cap of 50% on all reservations. Now I would request the court to kindly take note of this fact that today's backward classes consist of not only Hindus, but all other minorities, including Buddhists, Jains, even Sikhs, and Muslims. In other words, what was to be a separate provision under 296
Yes.
has now become a provision under 16(4) for all the communities, including the minorities. This is one major aspect I request the court to kindly take note of, to say that when 50% rule was judicially laid down in Balaji, this aspect has been lost sight of. Having said this, so if at all, now according to the 2011 census, the minorities population is around 17 to 18% in Karnataka. So if 296 was operating, only Hindu backward classes would be covered by the 50% rule of which Ambedkar spoke, and there would have been a separate provision for the minorities up to 17%. Be that as it may. Now, Constitution itself has undergone a very important change. Kindly permit me to show the newly added provisions under Article 15 and 16.
Yes. Yes.
Now, 15(4) was introduced by the First Amendment. Court may kindly recollect, there was only a provision for reservation in services under the state under Article 16(4). There was no other provision enabling reservation to be provided in educational institutions, particularly the professional institutions. So, Alladi Krishnaswamy Iyer, who was himself a member of the drafting committee, he questioned the reservation that was prevailing in the Madras presidency. In the famous case of Champakam Dorarajan versus State of Madras, which ultimately reached the Supreme Court, and State of Madras versus Champakam Dorarajan, court struck down that reservation, saying that there is no provision for reservation in the educational institutions. Fortunately, Baba Sahib Ambedkar was still the law minister, and the gap was immediately filled by introducing the First Amendment to the Constitution, and Clause 4 of Article 16 was added. Kindly permit me to read Clause 4 of Article 15. Nothing in this article or in Clause 2 of Article 29 shall prevent the state from making any special provision for the advancement of any socially and educationally backward classes of citizens or the scheduled castes and scheduled tribes. This held the field till 14/1/2019. Kindly mark the date, critical date, 14th January 2019. When a new provision was added to Article 15 by way of insertion of Clause 6, kindly permit me to read Clause 6 as it is now found in the Constitution. I quote, nothing in this article or subclause G of Article 1 of Article 19 or Clause 2 of Article 29 shall prevent the state from making any special provision for the advancement of any economically weaker sections of citizens other than the classes mentioned in clauses 4 and 5. Kindly mark it. This is a very crucial thing. So all those who are covered under Clause 4, namely socially and educationally backward classes of citizens, the scheduled castes and scheduled tribes, are disqualified to get the benefit of Clause 6 of Article 15.
Yes.
B. any special provision for the advancement of any economically weaker sections of citizens other than the classes mentioned in clause 4 and clause 5, insofar as such special provisions relate to their admission to educational institutions, including private educational institutions, whether aided or unaided by the state, other than the minority educational institutions referred to in clause 1 of Article 30, which in the case of reservation would be in addition to the existing reservations and subject to a maximum of 10% of the total seats in each category. Explanation says, for the purposes of this article and Article 16, economically weaker sections shall be such as may be notified by the state from time to time on the basis of family income or other indications of economic disadvantage. So with this development, namely the new provision, the consequences are the scheduled caste, scheduled tribes, and other backward classes who were covered under 15(4) who were also eligible for the 50% seats. They were not disqualified. They were eligible. Also eligible for 15 general seats are now disqualified to an extent of 10%. Because of the reservation in favor of PWs. And the more important development is that those general category candidates who are hitherto not eligible under 15(4) are the only beneficiaries who are eligible for reservation up to 10% under 15(4). Yeah. So the question before this honorable court is, as laid down by Balaji, kindly permit me to. Balaji, may kindly be referred to. Para 30, running page 17 in the paper book given by my learned friend. I'll not duplicate it. Volume 1, page 16. Why was this 50% rule invented? It's very clear. The genesis of this 50% rule may be noticed. Para 30. I read para 30.
Yes.
Yeah. That takes us to the question about the extent of special provision which it would be competent to the state to make under Article 15(4). Article 15(4) authorizes the state to make any special provision for the advancement of the backward classes of citizens or for the scheduled castes and scheduled tribes. The learned Advocate General contends that this article must be read in the light of Article 46, and he argues that Article 15(4) has deliberately and wisely placed no limitation on the state in respect of the extent of special provision that it should make. Article 46, which contains a directive principle, provides that the state shall promote with special care the educational and economic interests of the weaker sections of the people, and in particular of the scheduled castes, scheduled tribes, and shall protect them from social injustice and all forms of exploitation. There can be no doubt that the object of making a special provision for the advancement of the castes or communities there specified is to carry out the directive principle enshrined in Article 46, it is obvious that unless the educational and economic interests of the weaker sections of the people are promoted quickly and liberally, the ideal of establishing social and economic equality will not be attained. And so, there can be no doubt Article 15 authorizes the state to take adequate steps to achieve the object which it has in view. No one can dispute the proposition that political freedom and even fundamental rights can have very little meaning or significance for backward classes and the scheduled castes and scheduled tribes unless the backwardness and inequality from which they suffer are immediately addressed. The learned Advocate General, however, suggests that the absence of any limitation on the state's power to make an adequate special provision indicates that if the problem of backward classes of citizens and scheduled castes and scheduled tribes in any given state is of such a magnitude that it requires the reservation of all seats in higher education institutions, it would be open to the state to take that course. His argument is that the only test which can be applied is whether or not, having regard to the problem which the state is called upon to meet, the provision made is reasonably adequate or not. Thus presented, the argument is no doubt prima facie attractive, and so it must be carefully examined. Para 31. When Article 16.4 refers to the special provision for the advancement of the certain classes or scheduled castes and scheduled tribes, it must not be ignored that the provision which is authorized to be made is a special provision. It is not a provision which is exclusive in character, so that in looking after the advancement of those classes, the state would be justified in ignoring altogether advancement of the rest of the society. Kindly mark it. So it is for the rest of the society the concern is shown. It is because the interests of the society at large would be served by promoting the advancement of the weaker sections in the society that Article 15.4 authorizes special provision to be made. But if a provision which is in the nature of exception, kindly mark it again, it is in the nature of an exception, completely excludes the rest of the society, that clearly is outside the scope of Article 15.4. It would be extremely unreasonable to assume that in enacting Article 15.4, Constitution intended to provide that where the advancement of backward classes or scheduled castes were concerned, the fundamental rights of the citizens constituting the rest of the society were to be completely and absolutely ignored. So again, for the rest of the society, other than the scheduled caste. In this connection, it is necessary to remember that the reservation made by the impugned order is in regard to admission in seats of higher education in the state. It is well known that as a result of the awakening caused by political freedom, all classes of citizens are showing a growing desire to give their children higher university education. And so, the universities are called upon to face the challenge of this growing demand. While it is necessary that the demand for higher education, which is thus increasing from year to year, must be adequately met and properly channelized, we cannot overlook the fact that in meeting that demand, standards of higher education universities must not be lower. The large demand for education may be met by starting larger number of educational institutions, vocational schools, and polytechnics. But it would be against the national interest to exclude from the portals of universities qualified and competent students on the ground that all the seats in the universities reserved for weaker elements in the society. As has been observed by the University Education Commission, quote, he indeed must be blind who does not see the mighty as are the political changes. Far deeper are the fundamental questions, which will be decided by what happened in the universities, unquote. Therefore, in considering the question about the propriety of reservation made by the impugned order, we cannot lose sight of the fact that the reservation is made in respect of higher university education. The demand for technicians, scientists, doctors, economists, engineers, and experts for the further economic advancement of the country is so great that it would cause grave prejudice to the national interest if considerations of merit are completely excluded by wholesale reservation of seats in technical, medical, or engineering colleges or institutions of that kind. Therefore, considerations of national interest and the interest of the community or society as a whole cannot be ignored in determining the question as to whether special provision contemplated by Article 15(4) can be a special provision which excludes the rest of the society altogether. In this connection, it would be relevant to mention the University Education Commission, which considered the problem of assistance to backward communities, has observed that the percentage of reservation shall not exceed a third of the total number of seats, and has added that the principle of reservation may be adopted for a period of 10 years. We have already noticed that the central government, in its communication to the state, has suggested that reservation for backward classes, scheduled castes, scheduled tribes may be up to 25% with marginal adjustments not exceeding 10% in exceptional cases. The learned Advocate General has suggested that reservation of a large number of seats for the weaker sections of the society would not affect either the depth or efficiency or scholarship at all. And in support of this argument, he has relied on observations made by the Backward Classes Commission that it found no complaint in the states of Madras, Andhra, Travancore, Cochin, and Mysore, where the system of recruiting candidates from other backward classes to the reserve quota has been in vogue for several decades. The committee further observed that the representatives of the upper classes did not complain about any lack of efficiency in the officers recruited by reservation. This opinion, however, is plainly inconsistent with what is bound to be the inevitable consequence of reservation in higher university education. If admission to professional and technical colleges is unduly liberalized, it would be idle to contend that the quality of our graduates will not suffer. That is not to say that reservation should not be adopted. Reservation should and must be adopted to advance the prospects of weaker sections of society. But in providing for special measures in that behalf, care should be taken not to exclude admission of other communities. Kindly mark it, sir. It is to safeguard the other communities. This provision was contemplated. A special provision contemplated by Article 15(4), like reservation of posts and appointments contemplated by Article 16(4), must be within reasonable limits. The interests of weaker sections of society, which are first charge of the state and the center, have to be adjusted with the interests of the community as a whole. The adjustment of those competing claims is undoubtedly a difficult matter. But if under the guise of making a special provision, a state reserves practically all the seats available in all the colleges, that clearly would be subverting the object of Article 15(4). In this matter, again, we are reluctant to say definitely what would be proper provision to make. Speaking generally, kindly mark it, speaking generally and in a broad way, a special provision should be less than 50%. How much less than 50% would depend on the present prevailing circumstances in each case. In this particular case, it is remarkable that when the state issued its order on 10/7/1961, it emphatically expressed its opinion that the reservation of 68% recommended by the Nagan-Gowda committee would not be in the larger interests of the state. What happened between 10/7/61 and 31/7/62 does not appear on the record, but the state changed its mind adopted the recommendation of the committee, ignoring its earlier decision that the said recommendation was contrary to the larger interests of the state. In our opinion, when the state makes a special provision for the advancement of the weaker sections of society specified in Article 15.4, it has to approach its task objectively and in a rational manner. Undoubtedly, it has to take reasonable and even generous steps to help the advancement of weaker sections. The extent of the problem must be weighed, the requirements of the community at large must be borne in mind, and a formula must be evolved which would strike a reasonable balance between the several relevant considerations. Therefore, we are satisfied that the reservation of 68% directed by the impugned order is plainly inconsistent with Article 15.4. The petitioners contend that having regard to the infirmities in the impugned order, action of the state in issuing the said order amounts to a fraud on the Constitution. Now that again, I'll not trouble the court. The court struck down the reservation in its entirety, and it did not even accept the doctrine of severability, as a result of which the backward classes in the state suffered without any affirmative action in their favor, notwithstanding 15.4 and 6 for almost 2 generations. So, this is how the provision of 50% cap is conceived so as to protect the members of the other castes, rest of the society, other than the scheduled castes, scheduled tribes, and backward classes. Now, all the other members, namely the general category, is now covered under 15.6, as a result of which all castes and tribes are now covered by either 15.4 or 15.6. There is no community left out to complain. There is no community left out to say that we are ignored. In the process, another development is more important development. What was available to the backward classes to an extent of 50% has now, as general merit seats, it is now cut down by 10%. So what is now available is only 40%. Now, how much of 40% are you going to apportion? Definitely, it can't be 50%.
Look at it the other way. The general category doesn't fall into any other reservation category. Now the limiting is only 40%. And 40% of 90%. Therefore, what is your given percentage of 50% over 90%? What percentage does that make?
That is yet to be decided.
Of course it does.
I would say, now taking for example, I bow down to that observation. Taking for example the Karnataka situation. Said 90% and above is the population of the scheduled caste, scheduled tribes, and backward classes in Karnataka. Hardly 5 or 6 castes are left out from reservation category, and their population would not exceed 5 or 6%, and they are already given 10%. Now, where is the question of safeguarding their interest? At any rate, the 100% seat that was available to cut it to 50% in favor of the backward classes is no longer available.
No.
I therefore very respectfully submit that the 50% rule has been obliterated by the amendment with effect from 14 January 2019.
Yes.
And in the light of this development, how much of the remaining 40% would you apportion for the backward classes?
Yes.
How much would you give it to the economically weaker sections? Is it 90-10? Is it 70-30? It is yet to be decided. It has not been decided. I very respectfully submit Since 90% of the population is constrained to be packed in the 50% quota, and the remaining castes,
You're assuming that the 40% is not available to them. There's no exclusion there. The reservation doesn't mean those persons who, for the reserved categories, can't come into the non-reserved category. There's no reservation there is general. When you say that yours only 50% is accrued to them, that's not correct.
No, 50% was available to the backward classes as well.
As a reservation.
50% as reservation,
That's right.
50% as a general merit category. Now that has been cut short by 10% by economically weaker sections who have been given over and above their population. 10% is given. Therefore, the question of 50% ceiling has been obliterated, is my very respect.
Right.
More importantly, all the castes are now covered under reservation, whether under 15.4 or 16.4. And how to apportion the remaining 40% seats? Would it be equally distributed, or would it be proportionately increased? Is a decision yet to be taken. In that view of the matter, no judgment of the Honorable Supreme Court has addressed this issue of the obliteration. I therefore very respectfully submit that the Balaji rule, reiterated in Indrasani and subsequent judgments also, is no longer in operation in the light of the development of adding 15.6. I am fortified in my submission to say this. By the latest decision of the Honorable Supreme Court in Janhit Abhiyan. Janhit Abhiyan is available in volume
1344.
Volume 3 at 11.7 at 1344. Court may kindly recollect here 10% reservation was challenged on the ground.
Yes.
It exceeds 50% and therefore it is bad. In fact, I led the arguments in this case, para 12. My arguments are noted. Kindly come to (157)
at page 1510.
At page 1510.
(1510).
1510, para 157.
Yes.
I may be permitted to read from para 156. (1509). Breach of 50% ceiling of reservations and basic structure. That's the heading of this.
Yes.
Yeah, 156. A long deal of arguments by the learned counsel challenging the amendment in question had also been against the prescription of 10% reservation for EWS on the ground that it exceeds the ceiling limit of 50% laid down by this court in the consistent series of cases. Apart that this argument is not precisely in conformity with the law declared by this court, it runs counter to the other argument that this CWS reservation is invalid because of exclusions. If at all, the cap of 50% is the final and inviolable rule, the classes already standing in the enabled bracket of 50% cannot justifiably claim their share in the extra 10%, which is meant for a separate class and section, that is economically weaker sections. 157. Moreover, the argument regarding the cap of 50% is based, kindly mark it, is based on all those decisions by this court which were rendered with reference to the reservations existing before the advent of the amendment in question. 50% ceiling proposition would obviously be applied only to those reservations. I repeat, only to those reservations which were in place before the amendment in question. No decision of this court could be read to mean that even if Parliament finds the necessity another affirmative action by the state in the form of reservation of section or class in need, it could never be provided. As noticed herein above, the decisions of this court are rather to the contrary and provide flexibility within which Parliament has enacted, putting the amendment in question. So, emphatic declaration is 50% cap would be applicable only to the reservations that were in existence prior to 14 January 2019. A constitution bench has declared this. I therefore would respectfully
Read the
submit.
next paragraph.
Yeah, next paragraph, 158. In the above backdrop, relevant decisions of this court in regard to the 50% ceiling limit could be referred, but while reiterating that these decisions are applicable essentially to classes who are to avail the benefits envisaged 15.4, 15.5, 16.4 of the Constitution of India. That would again be only in respect of the provisions made prior to this provision was made. Because that apportionment of 50% will not be available at all. Now the reservation category would cover 60% of the seats available, 40% of the seats are left. How are these 40% seats to be apportioned? That is a matter which is res integra. I therefore call upon this honorable court to say 50% rule is obliterated and it is no longer in operation. So this would be my first proposition. I'll come back to the facts of the case. In case it is to be held that 50% cap is still to be enforced, then how I am entitled to show that this is an extraordinary case which permits the state to provide for this marginal increase that has now been made, taking the reservation up to 56%. Before I do that, may I request the court to kindly permit me to address another very important constitutional question that has been raised, namely, state has violated Article 338(9) and 338(a)(9) by not consulting the commissions constituted under those provisions, 338 and 339, for the benefit of scheduled castes and scheduled tribes. Kindly permit me to read the provision. It has been read. Kindly permit me to read the provision again. 338(9). I read 338(9), please.
Yes.
The union and every state government shall consult the commission on all major policy matters affecting the scheduled castes. Kindly mark it. If a policy affects the scheduled castes, it injures them, it prejudices them, or takes away something which is already given, thereby affecting them, then only this provision is attractive.
According to you, affecting means only adversely affecting.
Sorry,
According to you, the word used affecting only means adversely affecting.
I go down to that. Yes, only if they are adversely affecting. Now
Not
here,
positively affecting.
no, here,
Yes.
I would request the court to kindly take. This policy has not affected the scheduled castes in any way because their quota of 15% is intact. They are given 2% over and above 15%.
No,
That
is-
will not affect them.
That's all right. We followed your point. Your point
Yes.
is there's no, this affecting means only adverse effect.
Adverse effect, which is prejudicial to the interests of the scheduled caste, then it has to be consulted. I am fortified in my submission in this behalf by a division bench ruling of the Honorable High Court of Madhya Pradesh in the case of Devansh Kaushik. Devansh Kaushik versus a division bench of the Honorable Supreme Court, Honorable Madhya Pradesh High Court. ಅದನ್ನು ಕೊಟ್ಟಿದ್ದೀರಾ ಇದು ಕೊಟ್ಟಿದ್ದೀರಾ ಇದೆ ಕೊಡ್ತೀರಿ. This is reported in Devansh Kaushik versus State of MP, ILR 2024. Our copy ಕೊಡ್ತೀರಿ. ILR 2024. Page 621. A division bench presided over by Honorable Mr. Justice Ravi Malimat, the then Chief Justice. This matter relate to recruitment of civil judges and certain concessions were given for the benefit of scheduled caste, scheduled tribes and backward classes. Concessions were given. No right of theirs was taken away. Certain extra privileges were given. Now that was questioned on the ground that Constitution 338 is violated. I request the court to kindly permit me to read at para 58, page 727. It should be running page 298. Running page 298. That the amended rule infringes clause 9 of Article 338, 338A and 338B of the Constitution of India, since the statutory commissions have not been consulted. 58A. The three articles of the Constitution of India pertain to the National Commission for Scheduled Castes, National Commission for Scheduled Tribes, and National Commission for Backward Classes respectively. The duties assigned in Article 338(5) of the Constitution of India are as follows. Quote, 5. It shall be the duty of the Commission to investigate and monitor all matters relating to the safeguards provided for the scheduled castes under this Constitution or under any other law for the time being in force or under any order of the government, and to evaluate the working of such safeguards. B. To inquire into specific complaints with respect to the deprivation of rights and safeguards of the scheduled caste. C, to participate and advise on the planning process of socio-economic development of the scheduled caste and to evaluate the progress of their development under the union and any state. D, to present to the president annually and at such other times as the commission may deem fit, reports upon the working of those safeguards. Yep. To discharge such other functions in relation to the protection, welfare, development, advancement of the scheduled caste as the president may, subject to the provisions of any law made by parliament by the rules specified. Article 338(9) of the Constitution of India would indicate that the union and every state government shall consult the commission on all major policy matters affecting the scheduled caste, which reads as follows. Quote, the provision is quoted. Similar is the provision in Article 338A and 338B. Therefore, and mark the next sentence, it's only on major policy matters affecting the scheduled caste, scheduled tribes, and other backward classes that the respective commission should be consulted. So far as the reservation provided to the OBC, SC, ST is concerned, the same is not affected by the impugned amendments, nor is it the case of the petitioners that the reservation has been interfered with, kindly mark it, has been interfered with by the amendment. The reservations as granted to the other backward classes, the scheduled caste, scheduled tribes, have been maintained. Moreover, the duties of the respective commissions have also been enumerated, which do not fall within the purview of the aforesaid amendments. Therefore, the contention that clause 9 of Article 338, 338A, and 338B of the Constitution of India have been violated, in our considered view, cannot be accepted. So therefore, my very preliminary submission about these provisions is only if it is adversely affecting the.
This doesn't say that. Where do you read only adversely affected?
No, that is the when it says.
It says reservation is not affected and therefore.
Has not been interfered.
Yes, reservation has not been interfered.
Interfered. Therefore, it is not affected. My very respectful submission, 15% and 3% given is not interfered, only enhanced. A benefit is given over and above the rights they already enjoyed. Nothing is taken away. And therefore, it is not affecting. Secondly, kindly permit me to give a close reading to this provision. The union and every state government shall consult the commission. It does not say it should be prior consultation. So it need not be prior consultation. It can be
after your enactment has been.
After the
act has come into force, you can consult.
I wrote, yes, we have consulted.
No. According to you, consultation could be post. Even
can be. Since it is not mandated that it should be prior consultation.
What will be the consultation for?
Consultation. Now,
after you enacted the act, what will you consult them for?
To the
working whether they ratify your act or whether they consent to your act or not.
No, they have to, because it is not concurrence. Kindly mark it.
No. What will you consult them for after you enacted your matter? After the legislature has enacted the
act,
it comes into force. What is the consultation?
We have a policy into force, and that we are placing before the commission for the commission's consideration.
It can't be a meaningless consultation.
No, with great respect, it will not be.
After you have enacted and it comes into force.
Yes.
What else is the purpose for consultation?
No.
Not for entertainment. No. After your act is in force. Once your act comes into force,
please.
As far as the legislature is concerned, the matter is done and dusted. It's passed. Assent is given. There's nobody now. Only other realm now is left. Not even with the executive. Now it goes. The only institution that can possibly comment with it is the constitutional courts. It's out of the purview of even the executive.
I go down to that observation, but the language is very clear and it does not mandate a prior consultation. It can always be consulted even after the decision is taken for the commission to give its opinion or advice in the matter. And more importantly, and this is, I request the court to kindly permit me to show from the language. Who is mandated to consult? It is the government.
Yeah.
The union and every state government. Only the government is directed to consult. There is no direction to the state or the legislature. And the legislature, Karnataka legislature, has a plenary power to legislate on all matters which come within their field of legislation.
Yes.
Under Article 246, they have the exclusive and plenary power to legislate. And that has been done. Legislature is not under an obligation to consult. And therefore, the best that could have been done is, after the legislature passed the legislation, the government has consulted. And therefore, there is nothing wrong and no violation of 338. In fact, this matter was in Patali Makkal Kachi. My learned friend read that judgment. Kindly permit me to show. He has read out all the paragraphs except one crucial paragraph, which I mean, this will be volume 5, page 2261. Non-compliance with Article 338(b)(9) of the Constitution.
Referring to paragraph number?
101 at page 2313.
Yes.
101 was read as if the act is declared void. With great respect to the reading of that provision, this is an argument of the counsel for the petitioner, not a finding of the court. So I'll not trouble the court with paragraph 1. Hundred and 2 may kindly be permitted to be read. Given the language of the provision and its interpretation in Jayashree Lakshman Rao Patil, there need not be a detailed discussion about Article 338(b)(9) being mandatory. The requirement of consultation with an expert constitutional body is indeed mandatory, and it would be fatal to disregard the provision. However, kindly mark it, however, non-consultation by the state government with the National Commission would not take away the competence of the state government to enact the 2021 Act. So Act is valid, it is competent. Legislative competence can only be circumscribed by express prohibition contained in the Constitution itself. And Article 338(b)(9) does not stop the state from enacting a legislation in furtherance of a major policy matter, but states that the state government shall consult the Commission on such matters. So the law declared is that legislature is not bound by the consultation constraints.
Read the next paragraph. The next paragraph.
Next.
Paragraph next after that.
Yes, next para is important. The consequences of disregarding a mandatory consultation provision would normally render the legislation void, as it is in breach of an obligatory requirement to consult an expert However, we refrain from going into this issue in view of our earlier conclusion that the 2021 Act does not withstand scrutiny. So they did not decide the issue, but indicated that the legislature is not circumscribed by Article 338(9). My very respectful submission is the plenary power of the legislature cannot be subordinated to a provision of consultation, because it is unknown that a sovereign legislature is subjected to, otherwise it is not plenary.
Yes.
So therefore, my very respectful submission is 338(9) is not at all attracted in the instant case. For these three reasons. Number one, it does not affect the interest. Number two, it is only for the government, not the legislature. And number three, more importantly, it doesn't say prior consultation. So this is how my very respectful submission is in respect of the legislation. Because legislative wisdom, since it is not circumscribed by this, once a legislation is in place, consultation would be left to the government, which is mandated to hold the consultation. Had the provision said state shall consult, I respectfully bow down, even the legislature would have been covered by it. But and Article 246 also doesn't say subject to any other provision of the Constitution. May I read Article 246 for a minute? Kindly permit me to show from Article 246. Unlike so many other provisions which are subject to the other provisions of the Constitution, 246 is very emphatic in giving plenary power to both the Parliament as well as the state legislature to enact laws in exercise of their plenary powers in the respective fields of legislation. May I read subsection clause 3 of Article 246.
Yes.
246(1) deals with the Parliament. 246(2) deals with list 3. 246(3) is the provision under which this legislation has been enacted. It says, subject to clauses 1 and 2, the legislature of any state has exclusive power to make laws for such state or any part thereof with respect to any of the matters enumerated in list 2 in the 7th schedule. When the state legislature is given the exclusive power, the plenary power, the petitioners want it to be circumscribed by a process of consultation which is not warranted, is my very respect. So that argument on 338(9) and 338(9) is not to be entertained.
Yes.
Now the provision under attack in these petitions is not an executive order. What is under challenge is a piece of legislation enacted in its plenary power by the Karnataka legislature. And it is not anybody's case that it has exceeded its legislative competence.
No, competence is
Not in question, not in question. Having said that,
Violation of Article 40.
having said that, my very respectful submission is, yes, they have invoked Article 14, but as a piece of legislation, this legislation is entitled to the presumption to be raised in favor of it, to say that it is constitutionally valid, and a legislature has the freedom to enact a legislation in its legislative wisdom to lay down a policy. And the policy laid down is that the percentage of reservation should be 17 and 7% respectively for the scheduled caste and scheduled tribes. That it is within the legislative competence is not in dispute. That being the position, there is a presumption in favor of it. I request the court to kindly raise this presumption. I'll demonstrate that they have not discharged the burden to say that this is anyway. The presumption to be raised is now very well, it's a very settled this thing. Right from Charanjit Lal Chaudhary of 1950 Supreme Court, Constitution Bench, till the latest judgment, sir, I've given the list. I'll not trouble the court by reading all the judgments. Just last two
It's a
judgments.
settled proposition.
Yes, clear proposition. And more importantly, kindly come to 2019 6 SCC page 283. Federation of Obstetrics and Gynecology Societies starts at page 143.
Yes.
Para 74 may kindly be perused.
Yes.
Because there is a very short review of the case law, which is very important for the case on hand. Page 74 at page 189.
Yes.
I read para 74. Yeah. The Act enjoys a presumption of constitutionality. We find no violation of the constitutional principles. The problem of female feticide is worldwide and the matters of common knowledge. Reports and history are the basis of the legislation, provisions of which cannot be termed to be illegal or arbitrary in any manner. In Namit Sharma versus Union, this court has laid down, quote, the principles of adjudicating the constitutionality of a provision have been stated by this court in its various judgments. Referring to these judgments and more particularly, Ramkrishna Dalmia versus S.R. Tendulkar and Budan Chaudhary versus State of Bihar, the author Jagdish Swarup in his book Constitution of India stated the principle to be borne in mind by the courts and detailed them as under. A skipped B. There is always a presumption in favor of the constitutionality of an enactment, and the burden is kindly marked. The burden is upon him who attacks it to show that there has been a clear transgression of the constitutional principles. See, that it must be presumed that the legislature understands and correctly appreciates the need of its own people, that its laws are directed to problems made manifest by experience, and that its discriminations are based on adequate grounds. These are the presumptions to be raised. E, that in order to sustain the presumption of constitutionality, the court may take into consideration matters of common knowledge, matters of common report, the history of the times, and may assume every state of facts which can be conceived existing at the time of legislation. Unquote. The petitioner has not shown which of the entry is not mandatory in the form, as the entries are mandatory and sine qua non for undertaking a test, etc., etc. This is how it has been. The Act intends to prevent mischief of female feticide. The declining sex ratio, when such is the objective of the Act, and the rules and mischief which it seeks to prevent, violation of the rights under Part 3 of the Constitution is not found. This court in Hamdard Dawakana versus Union of India has laid down the following principles. Quote, therefore, when the constitutionality of an enactment is challenged on the ground of violation of any of the articles in Part 3 of the Constitution, the ascertainment of its true nature and character becomes necessary. That is, its subject matter, the area in which it is intended to operate, its purport and intent have to be determined. In order to do so, it is legitimate to take into consideration all the factors such as history of legislation, the purpose thereof, the surrounding circumstances and conditions, the mischief which it intended to suppress, the remedy for the disease which the legislature resolved to cure, and the true reason for the remedy. Bengal Immunity versus State of Bihar, RMD Chamar Bagwala versus Union of India. Quoted again. Another principle which has to be borne in mind in examining the constitutionality of a statute is that it must be assumed that the legislature understands and appreciates the need of the people, and the laws it enacts are directed to problems which are made manifest by experience, and that the elected representatives assembled in a legislature enact laws which they consider to be reasonable for the purpose for which they are enacted. Presumption is therefore in favor of constitutionality of an enactment. Charanjit Lal Chaudhary, F.N. Balsara, Motidas versus SP. And so, one other judgment. I'll just cite one paragraph from that. In Union of India versus Exide Industries, reported in 2020, volume 5 SCC, page 274. Kindly come to page 224.
Yes.
Then running page 224, internal page 291. Para 17 may kindly be permitted to be read. Only one para I'll read. In the present case, the legislative power of Parliament to enact clause F in the light of Article 245 is not doubted at all. That brings us to the next step of examination, that is, whether the said clause contravenes any right enshrined in Part 3 of the Constitution, either in its form, substance, or effect. It is no more res integra that the examination of the court begins with a presumption in favor of constitutionality. The presumption is not just born out of judicial discipline and prudence, but also out of the basic scheme of the Constitution, wherein the power to legislate is the exclusive domain of the legislature of the parliament. This power is clothed with power to decide when to legislate, what to legislate, kindly mark it, when to legislate, what to legislate, and how much to legislate. Thus, to decide the timing, content, and extent of legislation is a function primarily entrusted to the legislature, and in exercise of judicial review, the court starts with the basic presumption in favor of the power, in favor of the proper exercise of such power. Unquote. So, this is the law. I therefore very respectfully submit this piece of legislation, which has marginally raised, if we may say so with respect. I will also demonstrate 50% is not a mathematical rule. I will demonstrate it is only a marginal rise. And it is not it's a piece of legislation which has to be presumed to be constitutionally valid. So that is the next proposition which I have made. Having said this, my next proposition would be on the scope of judicial review. Now, courts have repeatedly laid down that it is the privilege of the state to decide on an affirmative action policy. The nature of such policy and the extent of its coverage. It is very famously said, the length of the leap depends on the gap to be covered. The length of the leap depends upon the gap to be covered. This is the famous statement made. I'll cite it. And the scope of judicial review, the court will only look into not the decision itself, but the process of arriving at the decision. The court will not substitute its judgment in place of the legislative wisdom that has been exercised. So that being the narrow scope for a judicial review, it is my very respectful submission that courts have repeatedly laid down that the percentage of reservation is not an issue which is justiciable. I'll start with Vasant Kumar. I had the privilege to appear along with my good and noble senior Mr. L.G. Havnur, who argued the matter.
Court officer, earlier one. Idhar munche kotti.
The Constitution Bench judgment which upheld the Havnur report, as it is famously called, that report was upheld by this Honorable Court, a division bench of this Honorable Court. Later, the Honorable Supreme Court upheld it. Just one paragraph, I'll trouble the court with only one paragraph. Para 57. Because all the judges have given separate judgments, but all of them are concurring. Para 57. at page 68.
Yes.
Here it, para 57. In Balaji, court then considered the question of the extent of the special provision which the state would be competent to make under Article 15(4). Here the court brought it the so-called meritarian principle and thought that large reservation would inevitably affect efficiency. We may perhaps mention here what a noted sociologist had to say. Quote, so the leading anti-reservationists try hard to find rationalizations to find nationalizations of their campaigns. A favorite one is to conjure up the image of phony juxtaposition. On one side is merit shown up by candidates on the open list. On the other side is incompetence represented by those on the reserved list. Hence, so the argument runs, if reservations are maintained, standards in the medical professions or in the other professions and senior government top posts will be deleted. Indeed, it is claimed there is a serious risk that patients will die if they are treated by backward doctors who have reached their positions through reservations. Such allegations are constantly repeated, although they are patently false. Kindly mark it. Although they are patently false. In the finals at the postgraduate level, the minimum qualifying marks are identical for all candidates, irrespective of their origin. Unquote. We should think that that is a matter for experts in management and administration. There might be posts or technical courses for which only the best can be admitted, and others might be posts and technical courses for which a minimum qualification would also serve. The percentage of reservation is not a matter, kindly mark it, I repeat, the percentage of reservation is not a matter upon which a court may pronounce with no material at hand. For a court to say that reservation should not exceed 40%, 50%, or 60% would be arbitrary, and the Constitution does not permit us to be arbitrary. Though, in Balaji case, the court thought that generally and broadly, in a broad way, a special provision should be less than 50%. And how much less than 50% would depend upon the relevant prevailing circumstances in each case. The court confessed, quote, in this matter again, we are reluctant to say definitely what would be proper provision to make, unquote. All that the court would finally say was that in the circumstances of the case before them, a reservation of 68% was inconsistent with Article 15(4) of the Constitution. We are not prepared to read Balaji as arbitrarily laying down 50% as the outer limit of reservation. What precisely was decided by Balaji has been summed up by this court itself at page 471 as in the following words, quote, we have already noticed that the impugned order in the present case has categorized backward classes on the sole basis of caste, which in our opinion is not permitted by Article 15(4). And we have also held that the reservation of 68% made by the impugned order is plainly inconsistent with the concept of the special provision authorized by Article 15(4). Therefore, it follows that the impugned order is a fraud on the constitutional power conferred on the state. We must repeat here that we have said earlier that there is no scientific statistical data or evidence of expert administrators who have made any study on the problem to support the opinion that reservation in excess of 50% may impair efficiency. It's a rule of thumb, and rules of the thumb are not for the judges to lay down to solve complicated sociological, and administrative problems. Sometimes it is obliquely suggested that excessive reservation is indulged in as a mere vote-catching device. Perhaps so, perhaps not. One can only say, out of evil cometh good, and quicker the redemption of the oppressed classes, so much the better for the nation. Our observations are not intended to show the door to genuine efficiency. Efficiency must be a guiding factor, but not a smoke screen. All that a court may legitimately say is that reservation may not be excessive. It may not be so excessive as to be oppressive. Kindly mark it. It may not be so excessive as to be excessive, as to be oppressive. It may not be so high as to lead to a necessary presumption of unfair exclusion of everyone else. I'll not trouble the court with the other paragraphs. Then in state of Punjab versus Hiralal, same volume, para, page 6.
Yes. Yes.
Please, para 8 at page 6.
Yes.
May I read?
Yes.
The extent of reservation to be made is primarily a matter for the state to decide. I repeat, the extent of reservation to be made is primarily a matter for the state to decide. By this, we do not mean to say that the decision of the state is not open to judicial review. Reservation must be only for the purpose of giving adequate representation in the services to the scheduled caste, scheduled tribes, and backward classes. The exception provided in 64 should not make the rule embodied in 16(1) meaningless. But the burden of establishing that a particular reservation made by the state is offensive to Article 16(1) is on the person who takes the plea. I repeat, the burden of establishing that a particular reservation made by the state is offensive to Article 16(1) is on the person who takes the plea. The mere fact that the reservation made may give extensive benefits to some of the persons who have the benefit of reservation does not by itself make the reservation bad. The length of the leap to be provided depends upon the gap to be covered. Kindly mark it. The length of the leap to be provided depends on the gap to be covered. As observed by the majority in Rangachari, quote, the condition precedent for the exercise of the powers conferred by Article 16(4) is that the state ought to be satisfied that any backward class of citizens is not adequately represented in its services. This condition precedent may refer either to the numerical inadequacy of representation in the services or even to the qualitative inadequacy of representation. The advancement of the socially and educationally backward classes requires not only that they should have adequate representation in the lowest rung of services, but that should aspire to secure adequate representation in selection posts in the services as well. In the context, the expression adequately represented imports considerations of size as well as values. Size as well as values, numbers as well as the nature of appointments held, and so it involves not merely a numerical test and a qualitative test that the adequacy or otherwise of the representation of backward classes in any service has to be judged. And if that be so, it would not be reasonable to hold that the inadequacy of representation can and must be cured only by reserving a proportionately higher percentage of appointments at the initial stage. In a given case, the state may well take the view that a certain percentage of selection posts should also be reserved for reservation of such posts may make the representation of backward classes in the services adequate. The adequacy of such representation being considered qualitatively unquote. It is true that every reservation under 16(4) does not introduce an element of discrimination, particularly when the question of promotion arises. It is an inevitable consequence of any reservation of post that junior officers are allowed to take a march over their seniors. This circumstance is bound to displease the senior officers. It may also be that some of them will get frustrated, but then the constitution makers have thought fit in the interest of the society as a whole that the backward class of citizens of this country should be afforded a certain protection, as observed by this court in minor A. Periyakuruppan versus State of Tamil Nadu. Quote, it cannot be denied that unaided many sections of this country cannot compete with the advanced sections of the nation. Advantages secured due to historical reasons should not be considered as fundamental rights. Nation's interest will be best served, taking a long-range view, if the backward classes are helped to march forward and take their place in line with the advanced sections of the people, unquote. There was no material before the High Court, and there is no material before us from which we can conclude that the impugned order is violative of Article 16(1). Reservation of appointments under Article 16(4) cannot be struck down on hypothetical grounds. Kindly mark it. It cannot be struck down on hypothetical grounds or on imaginary possibilities. He who assails the reservation under the article must satisfactorily establish that there has been violation of Article 16(1). So this is the scope of the judicial review that is contemplated. And my very respectful submission is this position is reinforced by the 9 judges bench decision in Indrasani. Indrasani at page, volume 1. No. 176.
Or not 8.
ಅದರಲ್ಲಿ 215. May I request the court to kindly come to page 215. This is a concurring statement in addition to what I'll read all the judgments which are known. Para 176, my kindness, whether the policy of government can be subjected to judicial review. That was the question which was answered. Para 176 at page 205. The action of the government in making provision for the reservation of appointments or posts in favor of any backward class of citizens is a matter of policy of the government. What is best for backward class and in what manner the policy should be formulated and implemented, bearing in mind the object to be achieved by such reservation, is a matter for decision exclusively, kindly mark it, exclusively within the province of the government, and such matters do not ordinarily attract the power of judicial review or judicial interference, except on grounds which are well settled by a criterion of decisions. Reference is made to various judgments. Then kindly permit me to show at para 529, page 365. Question number 7. Will the extent of judicial review be limited or restricted in regard to the identity?
Paragraph number?
529. Answering question number 7, scope of judicial review. Page 364, sorry. It should be at page 364 of the paper book that is furnished by Madam. Answering question number 7, will the extent of judicial review be limited or restricted in regard to the identification of backward classes and the percentage of reservations made for such classes to a demonstrably perverse identification or a demonstrably unreasonable percentage? This is the question, answered at 529. The answer to the question lies in the question itself. There are no special principles of judicial review, nor does the scope of judicial review expand when the identification of backward classes and the percentage of the reservation kept for them is called in question. So long as correct criterion, kindly mark it, so long as correct criterion for the identification of the backward classes is applied, the result arrived at cannot be questioned on the ground that other valid criteria were also available for such identification. It is possible that the result so arrived at may be defective marginally. It may be defective marginally or in marginal number of cases. That does not invalidate the exercise itself. No method is perfect, particularly when sociological findings are in issue. Hence, marginal defects, when found, may be cured in individual cases, but the entire finding is not rendered invalid on that account. The corollary of the above is that when the criterion applied for identifying the backward classes is either perverse or per se defective or unrelated to such identification, in that it is not calculated to give the result or is calculated to give the very nature of the criterion a contrary intention, a contrary or unintended result, the criterion is open to. So kindly mark it, unless it is either perverse or per se defective or unrelated, it can't be subject of judicial review. Next paragraph. The validity of percentage of reservation for backward classes would depend upon the size of the backward classes in question. Kindly mark it, sir. Very critical observation. It would depend upon the size of the backward classes in question. Pausing for a minute, I may respectfully submit that it is nobody's case that this is a case of robbing Peter to pay Paul. It is nobody's case that the scheduled castes and scheduled tribes are given anything over and above what they would have been legitimately entitled by virtue of their demographic strength. So this is very critical observation. I repeat, so long as it is not the validity of the percentage of reservation for backward classes would depend upon the size of the backward classes in question. So long as it is not so excessive as to virtually obliterate the claims of others under Article 16(1), it is not open to challenge. However, it is not necessary, and Article 16(4) does not suggest that the percentage of reservation should be in proportion to the percentage of population of the backward classes to the total population. The only guideline laid down by Article 16(4), as pointed out elsewhere, is the adequacy of representation in the services. Within the said limits, it is in the discretion of the state to keep the reservations at reasonable level by taking into consideration all legitimate claims and the relevant factors. In this connection, the law laid down directly on the subject in the following decisions is worth counting. So they review the entire case law. 536, they come to Hiralal. (537) is the summation. 537, this is how they conclude. To sum up, judicial scrutiny would be available if the criterion inconsistent with the provisions of Article 16 is applied for identifying the classes for whom the special or unequal benefit can be given under the said article. 2, if the classes who are not entitled to the said benefit are wrongly included in or excluded from the list of beneficiaries for special provision. In such cases, it is not either the entire exercise or the entire list which becomes invalid, so long as the tests applied for identification are correct. The inclusion or exclusion is only marginal. 3, if the percentage of reservation is either disproportionate or unreasonable so as to deny the equality of opportunity to the unreserved classes. Sir, kindly mark it. This is a very crucial observation. It should be a percentage of reservation either disproportionate or unreasonable so as to deny the equality of opportunity to the unreserved classes and obliterate 16(1). Here I have already made the submission. Only a handful of castes are left after the reservations provided under 16(4). So therefore, this is the critical test, whether the unreserved classes are denied the equality of opportunity. My very respectful submission is, this is the crucial test to be applied in the instant case. Whether the percentage is unreasonable or results in the obliteration of Article 16(1), so far as the unreserved classes are concerned, it will depend upon the facts and circumstances of each case, and no hard and fast rule of general application with regard to the percentage can be laid down for all regions and for all times.
How long further will you take?
Sorry,
How much further will you take?
I think 1 hour, about an hour. Tomorrow another half a day I should be able to. Tomorrow from 2:30.
Or it start, take it on Tuesday.
Tuesday. Very good. Obliged.
It is no other thing.